Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we're going to discuss the 150 days of Justice Dhananjay Chandrachud as the Chief Justice of India, achievements and also suggestions. Of course, there is so much that has been done in these past 150 days on the judicial side, on the non-judicial, which is administrative side. Also, we have a very vocal Chief Justice. He speaks his mind. We get a peek into his mind through his various utterances, which he is, in a sense, doing time to time. And it's a very welcome step because, we get to know how our Chief Justice thinks, what he feels on issues, not only just by his judgments, but otherwise also. So it has been, in a sense, a very interesting 150 days, which we're going to discuss today. I have a very eminent panel who joins me today on this discussion. I want to welcome Senior Advocate Amit Desai. As you all know, Mr. Desai is an eminent jurist. And I would like to say in a lighter way many times that he comes from the city of Mumbai, where he's represented both Mukesh Dhirubhai Ambani on the one side and Salman Khan on the other. So he's represented the top corporate in this country and the top Bollywood star. He has not left space for anybody else. So that's his introduction. Good to see you. And thank you so much for your time. I have with me Senior Advocate Arvind Nair, who practices at the Supreme Court of India, also the Delhi High Court and the National Company Law Tribunal, where you would see him practicing in various important cases. Good to see you, Mr. Nair, and looking forward to some interesting insights. I have with me Advocate Malak Bhatt. He's founding partner of NM Law Chambers, who with an office in Delhi, and they routinely do a lot of big commercial cases at the Supreme Court, at the NCLT, at the Delhi High Court, and other forums. Good to see you, Malak, and looking forward to some interesting insights from your end. At the outset, I want to go to Senior Advocate Amit Desai, and in the first 3 to 4 minutes, because I would like to reveal it to my audience, he has a unique distinction of a long association with Justice Chandrachud. So, he can give us that perspective. Can you, in the next 3 to 4 minutes, share your perspective on how do you view his 150 days as Chief Justice of India?
So, Tarun, it's a good thing that you do these programs which are retrospective at times and introspective at times. And I think that's very essential for the justice delivery process. And I think it's an opportunity for us every time when there's a change in the guard at the Supreme Court. You've taken the opportunity of trying to bring up forth the different personalities and persona of these judges. And you've done that with Justice Ladit, you've done that with Justice Chandrachud at the initial stage. Justice Chandrachud, of course, has the unique distinction of having a tenure of a little over 2 years, which I think is the longest tenure that any chief has had since, I think, if my memory serves me right, 2010, when Chief Justice Kapadia had approximately 2 years. So it's been nearly about 13 years since we've had a Chief Justice who's going to have a tenure of 2 years, a little over 2 years. And I don't think we're having another chief having a tenure of that, Chief Justice having such a tenure for probably another about 8 to 9 years. Now, considering this unique position in which he finds himself, his 150 days clearly indicates that he is a man on a treadmill. And that's just the energy that Justice Chandrachud has always had from his early days. And as you rightly said, he was practicing in Bombay. We've seen him practicing in the Bombay High Court. We've seen him as a judge of the Bombay High Court. And obviously, we've tracked him as he progressed in his career all the way up to the Supreme Court. And one has seen the same level of energy. And when you look at that energy, he comes with a lot of legacy from, being from a family of lawyers, from a family of judges, and have worked with, obviously, the brightest minds in the legal profession over the last 70, 80 years. So there's a significant legacy that he came with. And when you look at his last 150 days, I think in many ways you see that the learnings of all these last 30 to 35 years is coming out when he sits in that seat as the Chief Justice of India at the head of the institution of the judiciary. And when you see what's happening, and when you see the last 150 days, if you remember the first time when you had a show shortly after he became the Chief Justice, and his decision was in the context of personal liberty. I still remember his initial decision was 10 bail matters and 10 transfer matters to be listed every single day. I think that was a reflection about what he grew up with. It was all about the Constitution. It was all about 21. It was life. It was liberty. And that's what he's actually evolved. And you can see that as we see his renditions in various decisions. And we can see that in the current Constitution bench matter that's also currently going on. So when you see that, you see the changes that I'd like to talk about. I mean, of course, there's been so much of decision making that is there. His intellectual heft is known to all of us, and therefore his pronouncements, his judgments are there for all of us to see. But I think sitting here, the single most important changes that you see here are all on the institutional and the administrative side. I think the mission is to ensure that this institution, which has come in for a lot of criticism over time, whether it deals with vacancies, whether it deals with appointments, whether it deals with disposal, whether it deals with technology, whether it be citizen-friendly decisions, the whole range of issues which have sort of come in for debate in the last several years. I think he is trying to bring about change in that. He's trying to bring about balance in all those issues. He's trying to be, futuristic, because he recognizes where the future is. He's passionate about technology. He's determined about trying to deal with the reality of what the justice system should be looking like in the future. And when you see all that, and I mean, we can keep discussing every aspect, because when you think about it, they're like so many issues that he has actually touched upon, that he's got the energy and he's continuously working to make sure that, different facets of the institution, whether it's at the level of the Supreme Court, whether it's at the level of the High Court, or whether it's at the level of the district courts, it's at all levels that an effort is being made to try and make sure that the processes work, there's a simplification, there's a quick disposal. And this is where I can sort of keep talking about these issues for a fairly long period of time and break them down to, if you talk about technology, you talk about him translating judgments in so many different languages, and his effort is to actually translate judgments into all different languages. He does it by using technology. You talk about, obviously, VC and hybrid, that's always there. You talk about transcription. So in streaming, you remember the other day, he actually put up the screens in the Supreme Court, and as the arguments were being made, you could see the transcription of the arguments on the screens. So that's a whole new sort of technology that's being introduced, and slowly that will come into the court system. It's obviously, arbitrators are familiar with it, but the Supreme Court and the courts are not familiar. So this is all about delivery of justice to the common man. And this is something that he is very keen on ensuring that percolates down to the high courts, it percolates down to the district courts, so that access to justice, which is a 21 doctrine, is actually something that will work in the future. So technology is one thing and he knows how to harness technology and use it for the purposes of improving the justice delivery process for the citizens. You then can talk about, the effort to sort of fill up the vacancies. And, obviously the Supreme Court, after a long time, is actually working at full strength, and that's there. But the effort is actually to go down to the High Court and the District Court. And there's an interesting statistic, which I noticed, that in relation to the High Court, obviously the Supreme Court has made 8 appointments. In the High Courts, there's a net addition to the judges in terms of the vacancies. So he's pushing the envelope to ensure that there are more appointments than retirements. So today we have, in these last 150 days, we see a progress to see net additions in that. Take disposals. I see the Supreme Court disposal numbers in 150 days. In the Constitution bench cases which are listed in the last 150 days, he's disposed of probably about 12 to 15%, 12 or 13% of the cases that were pending before the Constitution bench. Obviously, the Constitution bench process was started by Justice Lalit, an excellent process that was put in place. He's continued it. But you've now managed to get about 12 to 15% of those cases just in 150 days. You then have the other disposals, where you are seeing a net reduction in the cases between the filing and the disposal in the last 150 days. So you again see that there's an effort with all the courts working at full steam. You see this process. So, I mean, you look at the statistics, you look at the numbers, you look at personal liberty issues. I mean, all bail matters. There's so many people who start getting bail in the Supreme Court. You're seeing the number of bail matters being reduced, but more important is the effort to try and ensure that the fundamental principle on bail law, which we've all been aware of for the last so many decades, that's bail not jail, is something that is now something that's being actionable in the various orders of the Supreme Court. So, I mean, one can sort of see so many things that are happening, and there are many more that we can keep talking about, and you have a limited time, and I don't want to take up the full period, but I mean, so I think there's a lot that's going forward, and so I mean, if this is what can be achieved in 150 days, I mean, remember he's got another about 570 days. So if you take it in blocks of 150, and this is the pace at which the institution is improving, then I think you'll see a dramatic change in the next 570 days that he probably still has.
Thank you for setting the tone, and thank you for this opening comment. I'll take this to Malak Bhatt. Now he's in a unique position between two senior counsels. Malak appears in court, but his law firm does a lot of matters at the Supreme Court of India. So he can talk as a lawyer who appears in court. He can also talk as a law firm who has experienced the Chandrachud system or the Justice Chandrachud system. Can you give me an opening comment on those lines?
Sure. Thanks, Tarun. In fact, as I always say that Mr. Desai is so close to Delhi despite not being in Delhi that he knows more about it than we. And I think he's already covered most of what we really had to say. And that's, that's the uniqueness of this discussion, that you have a perspective from someone who has seen Justice Chandrachud also from his Bombay days till the time he comes to Supreme Court, that he's seen what vision the man would carry and what vision would then transcend from him as a judge of the High Court to become the Chief Justice of the Supreme Court, and where that vision will actually lead. And I'll put this in two perspectives as an AOR of the Supreme Court on why the system change that he has brought about is actually something which is not only a course correction, but a visionary course that he has created for not just lawyers, but also citizens of the country. And I will, in my opening comment, just briefly touch upon where we are headed with the infrastructure and technological development that at least we've seen spearheading in the past 150 days. If you take cue from his latest comment, which took place last week, Justice Chandrachud has started the system of mentioning, which for the past many years had been done away with in the Chief Justice's court. Every day, regardless of whether he sits on a miscellaneous day or whether he sits before the Constitution bench, there are about 100 mentionings that take place on that day. And he has very well outspokenly mentioned this last week, that the reason for this mentioning is to give voice to the citizen of the country, that if you have an urgency in the matter, if you need an urgent relief from the court is here to help you to hear your voice and to decide the matter which you are bringing to the Supreme Court. I think it's a very fundamental point that he has raised, because today, with his comments that he makes in court, and we all know that judges, while they speak through judgments, they reach the citizen of the country only through the vision that they speak out in court. And he's been very outspoken about this, which comments we see in newspapers on a daily basis, that this is today a Chief Justice who is out there amongst the masses to help the citizen of the country on the matters that are coming to the court. The court will hear the matters in a timely manner. The process of listing is streamlined. The manner in which the matters will be taken up by the courts is regulated in a way that the advocate on record, and the client, the petitioner or the respondent who is coming to the court is assured of the fact that the process is put in place in a regulated manner. And I think that's a very, at a fundamental and a philosophical level, a very big change, because it's not as if this was not happening, but today, through a voice of the Chief Justice, to put this to the mass, that look, this is in place, and the system will ensure that the Supreme Court of the country is not just the Supreme Court of New Delhi. This, in fact, was his clear comment, that this is not a Supreme Court of Delhi, this is the Supreme Court of India. It's not just Supreme Court just of KG Marg. And I think that instills a lot of faith in the judicial system for the citizen of the country. And I think that's a very, very positive step. The second aspect is the infrastructural development that today we've seen span about in the way in which he's brought this about, and 3 or 4 very nice topics that he's touched upon. One is e-courts. The fact that today he has created equality not just amongst the citizens or the clients or the parties who approach the court, but also amongst lawyers. And a very positive development towards that is the fact that SCRs, the Supreme Court records, the judgments that the Supreme Court gives, are now made available on a free portal on the Supreme Court website. And he's very passionate about it, because I know that he's spoken about ESCR on an elaborate length. But the fact that today an equal opportunity and equal forum is being created for not just litigants, but also the lawyers, is his voice out to the community at large that, look, today we are now entering into a phase where the Supreme Court is going to place matters at a level which is much higher than it were till now. The last point, which Mr. Desai already touched upon, is the fact that now we are back to a system where old matters, what we in our common Supreme Court parlance called regular matters, are back on being taken up regularly on 2 dedicated days. So clients, litigants who have been waiting for a long time today know that you have 2 days in court where you will be heard. These old backlogs will be cleared, and that's a very, very positive outlook towards disposal-oriented judgeship. Things which, and on the administrative side, while we none of us know how difficult it is, but I'm pretty sure that it is a very difficult task to manage disposal. And in an age like this, where the inflow of matters into the Supreme Court on a daily basis is so high, to have a system where old matters are being looked at, are going to be catered to and dedicatedly disposed of, I think is a very, very reposing statement out there to say that justice will not only be seen to be done, but will also be done.
Thank you for your opening comment and taking us through the other administrative decisions as well. I'll go to Senior Advocate Arvind Nair. Now, you've been in the Supreme Court for a long time. What changes do you see in the Justice Chandrachud system? What observations do you have to make? You always have this sort of an interesting thing that you would like to give to issues. What is that take on Justice Chandrachud?
Thank you, Tarun. In fact, I must, before I make my comments, I must point out that my distinguished colleagues, Mr. Desai and Mr. Bhatt, really, I think they have touched upon everything, but I'll still attempt to add on it. According to me, the hallmark of even these 150 days is that I think it's apparent to anyone who has the slightest interest in the Indian judicial system and the Honorable Supreme Court, that by the time Justice Chandrachud retires, he's going to leave us all with a very, very solid legacy. I don't think that was ever in doubt. So, but I think we all probably did not realize the intense, impactful tenure. And I'll tell you why. According to me, the 2 most important factors have been, what has now happened is, what is his hallmark is being proactive and being accessible. I think, as Malak said, so many steps have been taken to make it very accessible. Information technology, I think everybody is talking about. He has been head of the E-Committee. Their suggestions have been sought. In fact, Malak said something about SCRs being made available on a free portal. Let me tell you, when I started my practice, one of the most common things words or sentences that we all heard from our seniors, and I'm sure Mr. Desai will agree with me, is that, we all had to save money and buy a library. That's how important judgments, especially judgments from the Honorable Supreme Court, were. So it's a huge step. I don't think the importance of it can be reiterated enough, of making Supreme Court reports available on a free portal. That's one. The second is, the court is now so proactive. I don't think, again, what my colleague said, I don't think in a long time we saw so many mentionings on a daily basis before the Honorable Chief Justice of India. Now we know that the responsibilities of the Chief Justice of India are not just restricted to what we see in court. That's only one part of it. There is a lot of administrative work that goes on. There are a lot of other initiatives that go on. But the number of mentionings are ranging on a daily basis from anything from 80 to 100, 110, 120. And I think what is very, very important and of critical importance is not only the number, the fact that you're mentioning can be number 20 or it can be number 100 on that list or that index, but we'll get the same kind of patient hearing. To add to that, it doesn't matter whether your mentioning matter gets called at about 10:45 or it gets called at 12:15 in the afternoon, because it has happened. We've been there in court. We've watched how patiently all these mentionings have been heard. So that's one part of it. Technology, we all know, but in technology also, there has been so much extra. I believe workshops have been carried out where there have been training sessions for visually impaired judicial officers. Now, I think when, on a daily basis, when you talk about information technology, you talk about access to video conferencing, you talk about access to e-courts. I'm not sure how many of us may have thought about the fact that there are visually impaired judicial officers, there are visually impaired lawyers, there are visually impaired advocates, and something extra needs to be done for them. So that's another initiative, which is why I use the word proactive. The other factor here is, in a way, there is also this whole demystification of the Honorable Supreme Court, in the sense that it's been taken close to the citizen. And I'll give you a very recent example. Every time you talk about constitutional courts and also the Supreme Court, we have this discussion, and I think we've all had occasion to hear this from our non-lawyer friends, about the holidays. Whether the summer vacation or the October break or the December break is a legacy of the Raj, or whether it should be done away with, and why does it still exist? Now, the Chief Justice of India very recently at a function, maybe it was the India Today conclave or something like that, was asked a question about the vacation. And I found an extremely transparent answer. So we have a head of the institution who's leading from the front, leading by example, and who believes in taking the bull by the horns. So a question was asked, and a very clear, a very lucid answer was given. I don't think we will find this question being asked again at any other seminar where honorable judges are invited as guests. It was explained that how critical these vacations are for judgments to be delivered, and how little time honorable judges of the Supreme Court actually get for any sort of recreation or time with their families, and how most of this time, in fact, nearly all of this time, is actually spent in dictating judgments. Because if you start dictating all of those lengthy judgments in court, then you may not be able to run through your list. Today, I think the shortest possible list is also an average of 50 to 60 matters, I think, and I'm talking the lower end of the spectrum, the shorter end of the spectrum. The other factor, again, touched upon by my colleagues, is the number of constitution benches, an initiative which began earlier, but which has been kept up, which has actually been sped up. I think, to my knowledge, and if I were to just sort of take names, there are at least 7 to 8 constitution benches which are either hearing matters of critical importance or are on the verge of hearing matters. We all know one matter which is going on, that's being reported every day. But there are so many other matters. There is a constitution bench assembled which will examine some group of companies' doctrine. Then there is a constitution bench which has been constituted, which will examine the Maharashtra issue. Whether the split in the party there, how it's to be adjudicated, what are the powers of the speaker. Then there is a constitution bench which will examine, powers between the lieutenant governor in Delhi. Then there is a constitution bench which will examine a challenge to reservations in Lok Sabha and state legislative assemblies. I think the title of the case is Ashok Kumar Jain versus Union of India. Then there is another constitution bench which will look at whether rules of the game can be changed in selection processes for public appointments. Then the army recruitment scheme, the Agnipath Agniveer scheme. So just look at the range. So I think we can't lose sight of the fact that given the kind of pressure, 100 mentionings, 150 mentionings, imagine the footfall, or in this case, the filing fall. How many cases are filed on a daily basis? And despite that, we have so many constitution benches which are lined up, which are going to hear and decide matters that will be very, very important. So I think proactive, accessible, transparent, taking it close to the citizen, and taking any questions or any comments that are made head on. I think, as Malak also said, and Mr. Desai also said, the Honorable Chief Justice of India is not afraid of speaking his mind. And what this has done is for the average citizen who maybe doesn't have a litigation pending and who only gets his information from either your show or from Bar or Bench or from the Times of India. It's actually, as I said, that's why I use the word, it's demystified the institution. They can see the Chief Justice of India, they can log in, they can be party to proceedings, they can hear what he has to say, questions are being asked, questions are being answered. We all saw collegium resolutions are being placed, the reasons were put out. So there is that great push of transparency. I think that is going to be the most important legacy.
Mr. Desai, in your first answer, you pointed out to this very important aspect of listing of 10 bail matters. Now, you have had the opportunity of appearing from some of the biggest industrialists in this country. If they were to find themselves in a situation where they would have had to appeal for bail. But we know in this country, it gets difficult to get bail from lower court. Sometimes you have to go all the way up to Supreme Court. Matters get stuck. Simply on that aspect, could you reflect on the fact that how it improves the business climate in India, this decision of Justice Chandrachud, and take us through the journey of these 150 days, that what kind of impact it has on the business community, because we know a lot of them are facing cases. You're not audible, I think.
Sorry. So, Tarun, I think, the Supreme Court and particularly Chief Justice Chandrachud, I think the core of their being is all about personal liberty. And therefore, one of the first decisions was to try and ensure that personal liberty issues are taken up right in the forefront. And he led by example in the Supreme Court by giving the directions and listing bail matters. You're undoubtedly seeing some kind of a downward effect of that. I think there's a lot more that needs to be done. There's a lot more push that's required, but at least it's moving in a direction. And I'm just hoping, because ultimately, I still remember one of the early comments in one of the public speeches that the Chief Justice made was about trying to guide the district judiciary, which is the original courts where these matters come up for the first time. They'll end up in the Supreme Court much later, is to remind them of the principle of bail, not jail. And the second thing, which I think was extremely important, was to tell them to pass orders without fear or favor. Now, very recently, just a few days ago, it is interesting for the Supreme Court to actually walk the talk, if I might say, because when a High Court issued a notice to a district judge to offer an explanation as to in what circumstances bail was granted, the Supreme Court, in fact, stayed that order and said you should not be asking these kind of questions to the district court. Now, what is the message in this? The message in this is about allowing the district courts where the accused first appear to pass orders on bail without fear or favor and implement the principles of bail, not jail. So when you see this happening, and this is something that I think whilst it has happened in the Supreme Court, this has to percolate a lot more down. And the encouragement, I think, for everybody, including the business community, is to see that there is a desire and there is an effort being made to ensure that this comes down. And I'm hoping that in the next few months or towards the end of this year, we will see a lot more of that having percolated down, because every high court is clogged with those cases. And that is causing concern to the system. In fact, if you remember, even the Prime Minister on an occasion had to speak about the question about liberty and under trials. So government is concerned about it. The Chief Justice of India is concerned about it. It has to very quickly percolate down. In fact, Justice Kaul in the Satyendra Anted has suggested that there should be actually a bail act which the government should come out with to simplify all these processes, because otherwise we used to hear of those stories and the statistics which were being laid before the parliament about so many people actually giving up citizenship and leaving the country. And that's something that obviously we need to make a serious effort to stop. And I do believe that, and I live with that hope and optimism, that we will see those changes down. We are already seeing it in the Supreme Court. We will start seeing a lot more happening at the High Court and the District Court levels where it needs to actually, start. And once that happens, you'll automatically see all these connected issues about backlog in the system, disposals, pressures, the concerns in the criminal justice system, a lot of those will start sort of unwinding themselves, and we will see a much better justice delivery system once that happens. But I mean, there are obviously some other topics that I'd like to touch upon outside of personal liberty. And let me just say this, that one of the future, which is where I think the future is, and I think the institution is moving in that direction. And I think they're working as a collective body. I think there's a lot more of teamwork that is happening. But, the key buzzwords, as you see in corporate sector today, is ESG. And you see that every day, and every corporate talks about ESG. Now, the question is, where do you see ESG in the institution? This is something that I see in the institution of the justice delivery system. When you talk about environment, you're seeing how the justice delivery system is moving towards paperless. That's a step in the direction of environment. I mean, I can break down many more examples of it, but this is one important salutary step in the context of environment. You talk about sustainability, social good. You're already seeing, as Arvind just mentioned, you're talking about how the justice delivery system, even for lawyers, is being made, and litigants is being made disabled friendly and differently abled friendly. So we have visually impaired, we have others who are now able to actually practice law, and who are also able to participate in the proceedings, and are also able to visit the courtrooms. Because you see courtrooms where now you have, the facility for a lot more facilities for the disabled to actually come and attend their own proceedings in court. You see a whole range of sustainability. There's a lot more that's happening. Governance, in the area of governance, you talk about the collegium system, and there was a conversation that used to happen about it being a club and closed door, etc. You're seeing transparency in so many decisions. So you're seeing at the governance level, apart from all the issues that we've talked about so far, in the one area where there was a concern between the government and about the way in which appointments are happening, you're seeing transparency happening. So you're seeing in different ways the concept of ESG coming into the institution of the judiciary. And this is something that needs to be done. I think the baton will be carried on, because the more important thing is for Chief Justice Chandrachud to ensure that, of course, he has his legacy, but the more important thing is the legacy of the institution of the judiciary, which is carried forward as one wholesome bit between one chief, because ultimately we always know there's always a court, which is by the Chief Justice, but I think that is rendering by the judgments. But I think at the institutional level, at the administrative level, I think it has to be one seamless process. And therefore, all the future Chief Justices will also, I understand, are always in dialogue, and there is a process of interaction, there's a teamwork, and one sees and hopes that this will continue. So you are seeing ESG in action, and one would hope that you see ESG to continue much faster in the justice delivery system. And
Thank you.
For the corporate sector and the government. So I think it's important. Sorry.
Thank you for taking us through all these points on the judicial side. I also want to ask now Malak Bhatt two things. There were judgments very interesting, like the fraud circular judgment which came out, which gave a relief to the industry. Could you want to reflect on that?
Sure. So in fact, this is an extension of what Mr. Desai had said, that for the business community, what exactly is it at large when it comes to Justice Chandrachud's tenure? And one interesting facet of that is that this is now a court which is marrying fundamental principles of rule of law into the ease of doing business. And this is very well reflected from his judgment in Rajesh Agarwal, where we were facing a situation where between 2012 till 2018, India saw a lot of fraud cases coming up. Banks were given a mechanism to detect and try and prevent perpetration of fraud in the banking system. And the RBI, in its own wisdom, came out with a circular to say you can declare an account as fraud. The argument from the government side always was that, look, this is a preventive detection mechanism. If you try and read in principles of administrative law, principles of giving rights to these perpetrators, so-called borrowers, it may lead to a dismantling of that system. It's very important at this point to understand that the mindset of Justice Chandrachud was that at no point in time can the fundamental rights of the business community or any citizen be given away in the garb of saying that this is in the interest, the business interest of the country. Because the importance of being heard, the importance of someone being heard at the stage before any civil or criminal ramifications are going to be faced is pivotal to ensure that an adequate right of representation is provided to that person. And I think it speaks volume of the fact that today this is a very balanced approach from the words of the Chief Justice of India to say, I am not going to be shielded by policy making, or I'm not going to give deference to policies to the extent they are in violation of vital interests of the business community. And that, I think, is a faith reposing judgment, which not only through the words in the judgment, but if you see the manner in which the hearing took place, there was a lot of emphasis placed on the fact that this is a core principle of administrative law which a bank as a custodian of public money ought to follow. And if there is something amiss there, then obviously the court will come to rescue. And I'll just take one more step ahead apart from this and touch upon what Mr. Desai also touched is regarding these bails. So as regularly practicing there, if you see day in, day out, we've been seeing that when the court started with listing 10 bail matters every day, now we have reached a place where on certain days, most of the courts don't even have bail matters or have one or two bail matters, which shows that in fact the disposal of these bails the threshold of the disposal is so high that we are able to achieve a situation where the courts need not be burdened with bails on a regular basis. And these can actually be tackled at the lower court or the high court level. And that's a very important mindset change that he has brought about, that these, and in fact, if you see a couple of the times, I think about a month back, he had made this comment in court that these matters, in fact, should not reach the Supreme Court, because Supreme Court ultimately is a constitutional court to deal with larger, important, substantial questions of law. The high courts should be emboldened enough to say the bail should be decided and be granted at that very stage, which is why, in fact, at a more supervisory level also, we've seen now with these comments and this reassurance that the Supreme Court through Justice Chandrachud has given, high courts have also started granting more bails. And as a lawyer appearing before him, I can tell you one very interesting personal facet about him is a judge who, and judges are also humans. We know that they do get swayed with the emotion of the case on the temperamental side. This is a judge who at 10:30 in the morning, if is denying you any relief, will deny you with a smile, with the same smile that he will have at 4:30 in the afternoon. And there are times where as a person you will feel the emotion that he carries on the matter. Sometimes you feel that the denial that he's given you on your matter may not justify your stand before the client, but you will feel that this denial was justified for you, and you will go back with a smile. And that probably is a very, at a advocacy level, a very big mindset and notional change that he's brought about to say that, look, this is not a court where you have to be scared coming in, or where you have to come in with a ammo to say that, look, if I'm not prepared to this extent, then I will be backtracked or I will be shouted upon. And this is something which over a period of time, through the process of live streaming, through the process of showing how he acts in court, is bringing about a huge change amongst the other courts also.
Okay, point very well taken. Thank you for taking us through a range of points, not just on the fraud circular. You also went into other areas, including bails, and explained to us. I'll go to Senior Advocate Arvind Nair for his comment on this issue. You're not audible.
Tarun, I think as Malak again said, most of it's been covered, but I think what has actually happened is when I was doing my opening comments, I used the word demystified. And I genuinely believe that what has happened is, you look for anyone, for people like us who are in court every day, we understand the variation in a case, we understand the merits of a matter, we understand that some days, not all days are same. But people who are on the edge of the profession, of the legal profession, or who are not directly involved, for them, there is this whole mystery attached to it as to how things happen. I think that has been taken down step by step. And perhaps it began with some of the landmark judgments, for instance, Puttaswamy, for instance, where, in the last few years, privacy was a very important issue that would often find its way in debates. A lot of people had their views on it, some for what kind of regulation could take place, social media. It's been an exciting time. There was lockdown 1, lockdown 2, everybody was home. Everybody had more time to reflect on a lot of issues and legal points that come up for debate. So that judgment came very clearly. We all knew about the importance of privacy. It was granted that constitutional protection, that it's a guaranteed right. So that's one. Just to stretch that, I think the message that has now today gone out and continues to go out on a daily basis due to various initiatives taken by the Honorable Chief Justice of India is that there is today an enhanced sensitivity. We can sort of try and explain it with various adjectives. Maybe, as I said, and then Malak also said, it's about patience. The mood which is at 10:30 or the mood which is at 4, it's the same. If a request is going to be rejected, it will be rejected with a very patient demeanor, so that you don't at least feel that you have not been heard. The other thing is there is this whole mood again, and it's sort of increasing, not for somebody like me or Mr. Desai or even Mr. Bhatt, but for somebody who's got maybe a party in person. And in fact, let me point out, I'm not for a minute saying that parties in person were not heard. In fact, the Honorable Supreme Court's always had this glorious tradition of giving a lot of time to parties in person, for various reasons. If somebody, and it's not always about affordability, it's also on several occasions, people who are in litigation, maybe family matters or promotion matters, service rules, etc., feel that they are better equipped to make submissions. And the Honorable Supreme Court has had this tradition. They've always given time. But I find that also on the rise. You probably walk into every court, you find 1 or 2 or 3 people who are wanting to make submissions in person. So I think that's connected to the initiatives that have been taken. I think the advent of information technology, the whole incorporation that we will hear you by VC. In fact, there are still courts where you have to send in a prior intimation, where you have to sort of give a reason as to why you are logging in and you're not physically present, but not in the Supreme Court today. You can just log in. So these are steps whose importance can't be overemphasized. This has led to a mood that there is this enhanced sensitivity from the highest court of the land. Every voice will be heard. It doesn't matter whether it's a intern, whether it's somebody who's just joined the profession, whether it's a party in person, whether it's an intervener. Every voice will be heard, and every voice will be heard with the same kind of patience. The other thing is, the Rajesh Agarwal was referred to. I've also had occasion to appear in some similar matters. Now, again, fusion and application of general principles of law to every subject. Otherwise, sometimes what has happened is, what we have seen is that some of the principles of natural justice or of administrative law may have been applied a little more in relative terms to a particular field of jurisprudence, maybe civil rights, personal rights, civil law, matrimonial law. But now, whether it's civil rights, whether it's matrimonial cases, whether it's commercial issues, whether it's interpretation of contracts, whether it's arbitrations, whether it's interpretation of the insolvency and bankruptcy code, the same principles are being applied uniformly. The same, so there is this fusion. Same principles are being applied. They are being read into everything, and there is this whole. I think Mr. Desai said about teamwork. I mean, there has always been teamwork, but it does appear, you get that feeling sometimes that there is a little more discussion, there is a little more consensus. Probably it's got something to do with the way the reasons for various collegium resolutions were published, because that important decision, which happened for the first time, could not have happened without a lot of discussion and consensus. So I think there are a lot of positives. There are a lot of legacy points. There are a lot of factors of impact which we see, but there is a lot which we are not seeing, which we probably only see in the mood, which is equally of critical importance.
Point very well taken, and thank you so much for sharing all this. The last word will go to Senior Advocate Amit Desai. What comment would you have to make as a parting comment? We're almost at the end of the show.
Tarun, I am very clear. I think I think what is important, and a lot of judgments will keep coming from various judges, and constitutional issue will get decided. I think the important thing for us is that at an institutional level, we need to make sure that the institution which everybody is talking about is creaking, it's breaking, it's crumbling. I think needs to be put together. It needs to be sort of bandaged. It needs to be stitched. It needs to be made a whole again from all the comments we hear and you read about on the citizens' expectations, the government's expectations. And I think this next, as I said, 570 days, if the last 150 days is an indicator of what has happened, I think the next 570 days is something which is a responsibility and in some ways a burden on Chief Justice Chandrachud to actually use this time, because it's not every Chief Justice who has this kind of time available to make sure that everything is happening. Because, Justice Lalit had probably the shortest tenure of 73 days and he still started something. And there were others who had 1 year and 6 months and 8 months. There's always this whole larger question, how much can you do in that much? I think Chief Justice Chandrachud has the 2 years, he has a time, and I think he's working on it. And that's what I would like to see over the next 2 years, is the institution where we all started off with the greats of the Ashok Sens and the Ram Jethmalanis and the whole lot of Soli Sarabjis and all. And we would like to see that institution at the level at which we grew up with.
Thank you so much, Senior Advocate Amit Desai, Senior Advocate Arvind Mayer, Malak Bhatt, Founder Partner, NM Law Chambers. Appreciate your joining us on a very, very important issue where we, in a sense, went over the tenure of our Chief Justice, the first 150 days. We will again do a show when he completes 250 days in office as Chief Justice of India. Looking forward to a lot more insights, and knowing Justice Chandrachud, he will give us a lot of matter and material to talk about.
Lots to discuss. There will
lots
be.
to discuss. Appreciate it. Thank you so much.
At very exciting days ahead.
Thank you so very much. Thank you so very much.
Thank you, Tarun, as always. Thank you.
So now we are joined by Advocate Rohan Shah, top commercial lawyer at the Supreme Court of India and the Bombay High Court. Good to see you, Mr. Shah, and thank you so much for your time.
Thank you, Tarun. Thank you for having me.
And so this is our series on the 150 days of Justice Dhananjay Chandrachud, the Chief Justice of India. If you could take us back to what you have observed in these 150 days. I know there is lots to talk, but if you could pick out a few instances and share with us of what you think has been the relevant parts of his Chief Justiceship and something that you would like to point out.
Tarun, I've been closely following your earlier programs where you've had a series of illustrious speakers speak to the same issue. And, for me, as I sort of look at these 150 days, it's important to probably reflect back to that first day, because I think everyone was full of really hope and expectation. And I think the most important thing is that in the 150 days, at least for me, that hope has been reaffirmed and probably been enhanced in terms of, what more can come beyond these 150 days. And few things which sort of stand out for me, particularly as a lawyer, and, as all of us as lawyers are sort of really abiding students of the law. Now, the one process which I find, appeals not only to me as a lawyer who's already spent sort of 30 odd years in the profession, but to my juniors in the chamber, and even to my dad, who all his life has been a businessman, is the transparency which has come in through the factor of the public at large being able to participate and listen in on the hearings which are happening before the Supreme Court. And I think, in this entire set of hearings which took place in relation to the political situation in Maharashtra, I think hearing the leading counsel of the country and hearing the 5 eminent judges and their interactions, I think was probably the most definite step to introducing the Constitution as a live document into the lives of people. And the number of people who have watched that broadcast outside of the law really has taken in a manner the justice system and the constitution literally to the screens and doorstep of the normal citizen. And I think that's a huge gain, because for a lot of people, the constitution is a revered but static document, doesn't really affect their lives. But for them to see the constitution at play, see the majesty of the constitution, see how it is almost a timeless document, I think that we have to thank the Supreme Court under the leadership of Justice Chandrachud, to bring those issues literally to the screens and doorsteps of a large number of people. I think the other thing which really stands out for me is, even in the administrative changes which have happened, I do find that there is a very solid human touch, because this whole system of benches daily taking up bails and daily taking up transfers really speak to two of the most fundamental issues in terms of bails and their impact on life and liberty, and the issue in terms of these transfers, many of which are really in the context of marital disputes. And there are families who are in a state of turmoil, there are children, young children in a state of turmoil. And these goes out and addresses these two extremely sensitive issues. The third thing that I notice is that for the first time, there is an acknowledgement that the legal system in its entirety, and particularly the Supreme Court, is technologically forward-looking, because it is not only in terms of the factors of the e-filing or the factor that, now online, you can sort of read almost 34,000 and more judgments of the Supreme Court in various languages. But, there were committees specifically set up, like the Committee on Case Categorization, which is headed by Justice Narasimhan. Now, that has a huge impact in the aspect of how you will categorize cases, and therefore, lends to not only a better quality of characterization, therefore, hopefully, allied and core issues being heard together, but also you will have an understanding that judgments rendered, what sort of impact it will have in terms of pending cases, what sort of impact it will have on, downstream cases within the judiciary. You also have a committee specially on AI in relation to translation, headed by Justice Oka. Again, very much a understanding of our ground realities of being a diverse nation of many languages and dialects, and issues coming through the system from the length and breadth of India, and therefore from really multiple language sources. And for us to again provide for this, I think is an acute and strong understanding of, who we are as a nation and a people. And the Supreme Court being sensitive to that, I think is really a very, very welcome signal. The other thing, of course, I notice is that, the aspect of the continuation on a regular basis of the Constitution bench, as a bench looking at issues of constitutional law and the impact of what happens in current society in the context of the Constitution, I think, again, restore the one very fundamental aspect of the Supreme Court really being the fountainhead of the entire judicial system, and in fact, the legal system. Again, to me, and I'm talking, of course, very personally here, but the factor that the Supreme Court is willing to take on several socially relevant and socially sensitive issues is again a signal that the Supreme Court is really walking step in step with where the people of the country are, whether it is in terms of their thoughts, in terms of their preferences, etc. I mean, I don't know how far the proceeding will go in terms of the same-sex marriage issue, but the fact that the Supreme Court is willing effectively to look at these issues, which is a reflection of really where we are in the context of society. And, these are real issues. They are permeating all over the world. And from that perspective, the willingness of Supreme Court to look at these issues. Now, there could be views on, where the boundaries are, etc. To me, the larger message is really the message in the context of a Supreme Court which is socially sensitive and socially open in the context of who we are as a society. And I think that makes a huge difference. To me, the last issue, which is, I think, of great relevance is, again, what the court has done in terms of jurisprudence in the area of rule of law and also in the area of the corporate space, which is where I spend most of my time. But this whole basis of the judgment on the sealed cover, and I think which will now always be known as the sealed cover case. The restoration of the primacy of views and opinions to be made available to society through the broadcast medium, and to say that that's a right which needs to be protected because it has a societal relevance. But within that, taking head on the issue in terms of information offered in sealed covers and really sort of bringing the curtain up in relation to that, to say that it is not every case that, you should really resort to that as government. And there are some extremely sensitive cases where that will still be relevant, but not a situation where you are not making a full disclosure and therefore offering a full opportunity. And I think that same theme really also has played out in the context of the willful defaulter case, the Rajesh Agarwal case, in the context of saying that, before you consign somebody to what people have referred to as civil death, to say that, they will then go under a situation where ultimately they come under such a heavy cloud that really for them to be able to function in the commercial realm almost becomes impossible. Reading in the aspect that in that sort of a situation, it is compulsory that there is full opportunity, it's compulsory that there is hearing, I think, again, will have a huge impact in redressing the faith in the system, in redressing the aspect that we are a rule of law society. And, this is what we will make available. And I think for me, as a nation, we are a nation where even a terrorist who was caught on camera in acts of terrorism, we gave a full trial. So I think it is really part of who we are in terms of our character as society, that due process in all aspects, particularly where the consequences are serious, must be read in and must be restored. So I think several of these, and just to sign off, I think, we are also in a phase in the leadership of Justice Chandrachud, where both the cohesiveness and the credibility of the Supreme Court, I think, is back to where it always deserves to be. I think we've had, all of us, incidents which have happened, I would think, in the last 5 to 10 years, which did not make us feel proud of, what those incidents were and the consequences that they had. But I think we are seeing this, what appears very clearly to be an extremely cohesive Supreme Court. And in addition to it being a very cohesive Supreme Court, I think the credibility and the stature of the Supreme Court being restored to where it rightfully deserves always to have been, I think is another, to my mind, remarkable achievement. And, may this just grow and may this multiply is what I guess all of us would hope as citizens.
Thank you. Thank you so much for that exposition in terms of taking us through his tenure, his cases, on the administration side, on the judicial side, on the non-judicial decisions that he's taken. Also, in about another 90 days or so, we want to do what we call the 250 days of Justice Chandrachud. There will be a lot more to reflect then, because as we speak, many important cases are being decided by the Constitutional Bench. Many important cases on the commercial side. Rajesh Agarwal is one such case which you mentioned when you spoke about the Chief Justice of India. There will be, I think, many more to come. So thank you for joining us, and would request for your time that time. Until then, thank you so much for joining and speaking on the Chief Justice of India, Justice Dhananjay Chandrachud.
Thank you, Tarun.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.